Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is why choose one? Antitrust as an enforcement tool for financial services. Going back a number of years, there have been very large investigations and ultimately findings in the financial services industry. These often involved claims that there had been unlawful collusion involving trading and similar activities. And the activities are actually subject to multiple regulatory regimes, including antitrust, but also, for example, fraud. So today we're going to talk to a former prosecutor about whether antitrust is the right enforcement tool for enforcement in the financial services industry. My co-host today is Jana Seidl. Hi, Jana.
Hi, John. How's it going?
Great. Jana, what are we doing today?
So we are going to talk about the crossroads of antitrust and financial services, as you've already mentioned, and we're going to cover briefly what we've seen from the DOJ so far on this and where we may go. So we'll talk about the background of what we saw in DOJ's LIBOR and FX prosecutions, and then we'll discuss whether to expect antitrust to be applied going forward to conduct like wash trading, high-frequency electronic trading, manipulation of crypto platforms, and the like, and just some thoughts and lessons learned of what we've seen so far.
Great. Who's our guest?
Our guest is Ben Sirota. He's a principal at Cobra & Kim, and he focuses on global competition matters, white-collar criminal defense, regulatory enforcement, and internal investigations. Ben was previously with the DOJ as a prosecutor for several years, and he has extensive experience litigating disputes touching on the financial industry, including those involving claims of price fixing, fraud, like you mentioned, and market manipulation.
All right, let's bring him in. Ben Sirota, welcome to the program.
Thank you. Glad to be here. Thanks for having me.
So let's get started, Ben, and we'll dive right in. So why is it important, what we're talking about here today, whether or not antitrust is the right tool to use or if fraud can do it all?
Well, thanks for having me. These issues are very near and dear to my heart because I worked on them both at DOJ and now back in the private sector, mostly on the defense side. So thanks for the opportunity. Love to talk about them. I think what's important here is to recognize that what happened in the 2010s, from my perspective, with these massive investigations into the financial markets, where antitrust was applied and fraud theories were applied, is not, in my view, a blip. In other words, the series of factors that coalesced back then to turn out all the enforcers from DOJ antitrust, from the criminal division fraud section, from tons and tons of civil regulators like the CFTC and elsewhere, that is a series of factors that are poised to reoccur potentially in the future if the right fact patterns come across, and that these are enforcers who are kind of poised and ready to pounce, in part based on the success that they experienced in the past. So we're going to talk, I'm sure, in the future about some of these new contexts in which these issues might occur. But my overall thesis is that antitrust theories are very much waiting to be applied to some of these financial market patterns.
It's interesting, Ben, because there hasn't been a lot of activity or a lot of investigations, I guess, reported since the sort of the heyday of the financial services antitrust investigations 8-10 years ago. Hard to predict where the next one's going to come from, right?
Yeah, I think that's true. I think a lot is going on, right? Back in the 2010s, which most people think about as really the high watermark of some of these scandals and prosecutions, a lot of that activity was sort of flowing out of the financial crisis. a lot of the activity was what we now might think of as kind of traditional financial market activity, like traders doing certain things with submissions, some sort of fairly old school kinds of financial market activity. It is possible that the new wave of these prosecutions and investigations, if in fact those new waves happen, are going to be in financial market sectors that the prosecutors haven't looked at too deeply traditionally, but are now increasingly important aspects of financial sector activity. Things that we'll talk about more deeply, like cryptocurrency, right? And so, it's hard to predict these things, but do know that at the Antitrust Division, they are trying to educate themselves. They've been very public about this on these new forms of activity and are very sort of keenly looking at them to see whether they can pounce and whether they're new cases for them.
So you touched on some of the historic cases that we've seen. Can you talk about some lessons learned and what might be possible challenges for prosecutors going forward, given your history on one side and now being on the other side?
Sure. So I'll talk a bit about the LIBOR case, and most of your listeners probably know about that, but very briefly, LIBOR is an incredibly important international benchmark rate, and the evidence was that traders both within banks and across banks were doing things with the submissions, and the allegation was to change the rate and benefit their own positions. And then the foreign currency investigations, of which I was a part, so I won't go into great detail on them, dealt with traders of foreign currencies at different banks doing things in tandem. And the thing about these cases that was really interesting, and particularly when I was a line prosecutor looking at these issues, is how much easier from a pure legal perspective it was to prosecute the cases as antitrust cases rather than as fraud cases. And to back up for a second, fraud requires proof of a lot of elements. You got to have a certain bad intent. You've got to be seeking to defraud someone, and there are different ways you can prove a scheme to defraud, but you have to be effectively trying to take money or property from someone. So there's an effect sort of component built into that, even if it's not successful, sort of an intended effect, right? And for an antitrust case, the requirements are actually much more simple. You have to show two competitors doing something together, and what they're doing has to be bucketed within three categories: price fixing, bid rigging, or market allocation. But if you can take the financial market activity that two or more bankers or traders are doing together and say what it is agreeing on price or rigging bids or offers or allocating customers, things of that nature, and if you're successful in persuading a court that's what it is, all you need to show is that these two or more traders or bank employees agreed to do that. And then the job of the prosecutor is effectively done. Now, of course, there can be battles on the facts. There are battles on the facts. But legally, the requirements are simpler than proving a fraud case. So that's why my overall thesis is that, when prosecutors are going to be looking at fact patterns in the future, they're going to consider, I think, whether antitrust should be applied if they have the right facts, because just from a legal perspective, it can be easier.
In terms of what theory is ultimately prosecuted, does it matter which portion, what part of DOJ hears about it first?
The short answer is yes, but usually people within DOJ will talk. So there on the margins, it does matter, meaning if something kind of comes in to the non-antitrust components first, that will often sort of start something as, a fraud or non-antitrust investigation. And clearly, if something is reported to antitrust, particularly if it's in the leniency context, it is going to start as an antitrust case. But in my experience, at least on both sides, if the case is big enough and prosecutors sort of smell that something is going to grow into a major international scandal with some major dollar signs attached, everyone is going to get a seat at the table. And I mean that quite literally, meaning, from both sides of my time, both the government and private sector, for these massive cases, you'll be in a room And there is a representative often of like 10 different components, DOJ components, CFTC, Treasury, all sorts of different people want to be at that table. And so the very long-winded answer to your question is it can matter at the margins how the case first comes in, but ultimately everyone is going to be smelling blood and wanting a piece.
So you mentioned all the different stakeholders that are interested in cases like this, including the SEC and the CFTC. How do they go about kind of, I guess, spreading the work out between each other, and how do they approach these cases?
So, I think sometimes there's this tendency to think that there's an incredibly top-down approach on all of these kinds of cases, and that someone sits down and kind of maps out perfectly who's going to take the lead in certain area versus others. And that may happen in some cases, but I think the truth of the matter is it's often sort of iterative and circumstantial. As I said, it may matter on the margins how the case first comes in, but then you have different teams of prosecutors looking at the evidence from different angles, and of course, civil regulators as well. And kind of it's worked out over time, in my experience, how these cases get handled, who's going to take the lead versus others. As it gets closer to trial, once the evidence has been investigated, sometimes it's a trial optics kind of issue, right? In other words, if we're trying a case before a jury, do we want to have a fraud charge in there because that feels different than just an antitrust charge? Or is the conduct truly antitrust conduct at its core? Meaning what we're really trying to get at is the interrelationship between two or more financial entities, and the fraud, if it exists, is sort of secondary. So there's no kind of one pattern to this. It's kind of worked out over time in my experience on both sides.
And you touched on the current appetite to do these cases as antitrust cases. Do you think that's a trend that's going to continue into the current administration?
I think so. And that may be a slightly counterintuitive thought because this sector has not gotten the same kind of attention as a general matter than some of the other sectors that the administration is very publicly talking about wanting to investigate. So obviously tech gets a lot of attention for very obvious reasons because the big civil investigations going on, but also agriculture and lots of other industries. I think if you piece together the data, though, there really is still a lot of hunger within DOJ, at least, to look at financial market conduct. There were a variety of speeches, for example, in 2020 made by various senior officials within the Antitrust Division, where they talked about really being interested in all of these new forms of activity, things like algorithmic trading, not so new anymore, by the way, but new from a sort of gross historical perspective. Things like cryptocurrency. And on some occasions in these speeches, they said things like, we really want to learn and we are paying to put prosecutors within various training programs so they can learn how these work. So, I thought that was actually a very candid admission, didn't get a lot of press, but a candid admission that, there are prosecutors who want to look into these things. There are senior officials who recognize maybe an information deficit there, who want to get their prosecutors up to speed. And they're certainly going to be looking to bring a case if they possibly can.
I'm glad you brought up algorithmic trading. I find it incredibly fascinating. And the thing that really gets me thinking is when you have humans reaching an explicit agreement to use technology to fix prices, that's one thing, right? So that's the application of antitrust there seems pretty straightforward. But as algorithms and software running them become more sophisticated, that coordinated behavior that we typically look at for antitrust cases may become more common without the explicit instruction by humans, right? So how do you expect that may play out, and how do you think antitrust can be brought to bear on cases like that? And should it be?
Yeah, it's a really fascinating question. I mean, the truth of the matter is, under U.S. law, at least, to bring a criminal case, you do really have to have a human-to-human kind of meeting of the minds, right? And it can be proved through sort of tacit, circumstantial evidence. It doesn't have to be two people saying, we hereby agree to do something. But there does need to be a human element in all of this. But, the fact patterns are murky. And so you could foresee a scenario where you do have two humans from competing institutions sort of cooperating at some early point in how an algo might work, right? And then the algos are set loose and the algos sort of react to each other, talk to each other, as it were. And the question is going to be kind of what is a sufficient evidence of those early communications? And if there are certain factors built into the algo, is that going to be enough to evince price fixing if then the algos are sort of set loose? I think under current U.S. criminal law, it's going to be tough to bring a case like that. But that doesn't mean that the U.S. won't be looking at jurisdictions like Europe where it might be somewhat easier to bring a case like that. And then, of course, there's also the option of trying out a case civilly, right? So if this is sort of too new and the evidence isn't sufficiently great to withstand a beyond a reasonable doubt standard, maybe you'll see some civil cases in this area, kind of more along the lines of kind of an information sharing theory rather than a crisp criminal agreement.
So we have not seen, Ben, I mean, you talk about some of the emerging areas where this may come up. What we haven't seen, at least in the last few years, is a really juicy cartel coming out of the largest banks. And part of the thesis that this being the case is that the banks have invested heavily, or some of them at least, have invested heavily in compliance, making sure that people understand the types of behaviors better than they did 8-10 years ago. Where do you see the next cases coming from?
It's a great question. I think that certainly could be a factor. In other words, compliance has caught up to some of these practices. But what the banks do and what all financial institutions do is changing so greatly. So the proliferation of electronic trading, so much more of the volume is traded electronically than once was. Proliferation of these algos. And the possibility that traders, sometimes with, by the way, totally non-nefarious purposes and maybe otherwise, might be engaging in incredibly quick trading, things that prosecutors might call spoofing, but that some traders might beg to differ is actually not spoofing, but just incredibly quick submission of bids and offers in the market. You might have traders from different banks trading with each other on a much more frequent level. You might have algos from different banks or financial entities trading with each other on a much more frequent level. And the more that you have banks sort of trading back and forth, right, the more some prosecutors might ask the question, wait a second, isn't this more like a non-traditional form of wash trading, right? So the very old school notion of this is like two stockbrokers who are trading back and forth in order to build up the price, and it's a pump and dump kind of scheme. Once you have unbelievable volumes of electronic trading going on, is it possible that algos will be acting that way? Is that analogous to wash trading? Is it not? Do they just happen to be trading back and forth because they're making kind of nanosecond by nanosecond calculations of where they want to hold volume, right? There's no clear answer to this, but these are the kind of newer forms, I think, of activity that prosecutors are going to get interested in, and ultimately, to make their cases in the court, try to analogize it to those very old school models like wash trading, right?
But there's where it gets tricky, right? Because those, when you at the top, you explained to us, I think correctly, look, if you want to bring an antitrust case, have an agreement on something bad, on one of the three bad categories, right? The question is in something like a wash trade or some of these things, is that really an agreement that falls into one of the, is it really an agreement to begin with, number one? And if so, is it one of the agreements that falls into the buckets? I mean, I think we're talking about unknown unknowns at this point, right? But I think really that's going to be the hard question. And if there isn't a clear agreement, then I think you probably need to shift back to thinking about bringing it under fraud or a different theory.
Right. So I think those sort of debates will continue. Those debates were very, very much there, by the way, in LIBOR, in FX, in a lot of these rate rigging cases that were pursued civilly as well. The question is really, if you have two traders from banks or other financial entities that compete at a high level, right? Are they acting as competitors in the moment in which the government wants to focus the case, right? Are they, when they're trading back and forth, as counterparties? They're not competing in that trade because they're actually acting as on others two different sides of the trade. But are they competitors in some sort of higher from a higher level perspective? And interestingly, all those arguments were made in the criminal cases in the 2010s, in the civil cases, and for the most part, with some exceptions, the judges hearing those arguments would say, well, you know what? If I've got a trader from Morgan Stanley, if I've got a trader from JP Morgan, those are competing banks writ large, and those two are agreeing on price, and it's not in the context in which they're just trading with each other in a very ordinary course way. I'm gonna say the government can call that price fixing, right? Or if these two individuals were to submit bids at the same time in a coordinated way in the market, I'm going to say that could be bid rigging. And there were very heated debates on all sides. And in the civil cases, some of the judges really, I think, identified with those defense arguments a bit more. But on the criminal side, for the most part, the judges let the government sort of stick it into one of the three categories the government desired to do so.
Well, interesting stuff. I tend to agree with you that I don't think this is an administration that's going to say we should give the banks a free pass for sure. While they may not have been listed in the top 10 or the top 5 or whatever we've heard listed in terms of industries that are getting a look, I think you're probably right that there will still be vigilance in looking in the financial services, and these are areas where there's still much to learn. I guess the last question I have for you, Ben, is if you have a case that is truly novel, is it harder to bring it as an antitrust case than as a fraud case? Because we kind of know what fraud feels like. With antitrust, whether it's one of these agreements, whether it falls in, is that maybe where the break comes and fraud becomes a little bit easier? Or do you just do both?
Yeah, I think prosecutors are going to look to do both. Belt and suspenders is always a good strategy if you're on the government side. I do think that some of these arguments about the novelty of the conduct are going to come into play perhaps more now if the government goes into cryptocurrency and algorithmic trading, maybe more so than the rate setting cases in the 2010s. Although, again, those arguments were really, really brought out at the time, and generally they failed. And so, yes, I do think that if it seems like it's going to be a real stretch to fit conduct into one of the traditional antitrust per se boxes, prosecutors might not do it. But my overall point is they had success in the past from a legal perspective. And so I think they're going to try to do it again if they can.
All right. Well, stay tuned. Watch the space. We'll see how things develop and have you back as things do. Let's shift here. Ben, what advice do you have for a young lawyer that wants to do what you do?
It's a great question. This might be somewhat counterintuitive advice, but my overall advice is to fail. And not sort of fail intentionally, do something with the intent to fail, but sort of put yourself in a position that you're taking some risks and thinking out of the box, doing things that are a little odd or counterintuitive, and they won't always work out. And some of that is going to be quite fine. You don't want to fail on something major as a general proposition, but if you fail at something minor, in my experience at least, it is a learning experience, and things tend to be iterative, and you kind of adapt for the future. So I think being really, really careful can sometimes be at odds with succeeding, particularly as an antitrust lawyer where things are so in flux and changing. So, be a little nimble and try to mess up every now and again.
So I as somebody who has regularly failed, I typically don't refer to that as failing, though. I refer to it as an interim setback because typically whatever that setback is, a lot of times it becomes a learning experience. Ben, I mean, is there an experience that you had where it looked like a failure at the beginning, but in the end it turned out to be a real learning experience?
I mean, that happens with some frequency, I would say, on cases where, in other words, you kind of put a lot of your eggs in a particular basket. You think you're going to have a really, really winning argument, and you might spend much less time on some alternative arguments. And then you lose on the primary argument. And sometimes it could be a really great thing because it kind of deflects and moves the attention to something else, where in the end, you had a much better case. So yeah, that happens, I'd say, on cases a lot of the time. And that's why I think as a general matter, as a litigator, you don't want to, just go with one theory because, sometimes you may just be wrong on that. And so you always want to have a backup and be nimble if you have to swerve.
Okay. Very helpful. So next question, Ben, tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Geez. Okay. Well, I will say one slightly off color thing, not too off color, but my last name actually means illegitimate child in, I think, Ukrainian or wherever my ancestors came from a long time ago. So whenever I meet another Sirota, which is actually more common than you might think, I always look at us like we all have this sort of interesting, scandalous backgrounds, like from a 19th century romance novel or something like that.
So what you're telling me is Jon Snow really should have been John Sirota?
I think so. I mean, I think that's basically what my last name means. I can tell you I would not have survived in a single day on Game of Thrones.
I think you could have made it at the wall. I really do.
I just, you have to have something. You have to have either brute strength or unbelievable strategic sense. And I don't think being, a passable antitrust lawyer is going to cut it. So, I could try. I mean, I guess there's some parallels between merging companies and sort of, merging alliances, things like that. But tough out there beyond the wall.
Okay. It felt like you were going to say there was another interesting thing you wanted to tell us.
Oh, this is something that may intrigue your listeners. I'm not sure, but I've become somewhat obsessed with this recently, which is if anyone travels to New York City, or if you live in New York City, spend a little bit of time in Central Park. Almost every bench there has a plaque, and the plaques basically are families typically honoring people who've passed. And, we go to Central Park all the time, and I look at these plaques. And for one day I said, let's look at who these people were. And I went down the rabbit hole of not only learning the stories of these people who are memorialized, which often are incredible, but often you find these unbelievable links. Like I found that someone on one of the benches is related to my wife.
Oh, wow.
Just total coincidence. We sit down on a bench, I look up the person, and it's like a distant cousin of my wife, right? So, it just gave me this unbelievable sense of connectedness just from looking at some plaques. It was really fun.
Let's go to our final segment that we call the Curious Hat.
And now it's time for the Curious Hat.
In my right hand, I have a series of questions, and they are numbered from 1 to 25. When we're together, we typically pass a hat, and the guest gets to choose the question out of the hat. We ask that question. Since we're not together, I'm going to ask you to choose a number from 1 to 25, and I will ask the question that corresponds with that number.
I'm going to go with number 17.
Okay. Number 17. What was your favorite course in college?
In college? Oh, I would say I took a class on American Studies. I think it may have been in the history department, but we read tons of novels, like early American novels going up to then the 1800s, and just anything in college that combined amazing writing with history, often then with philosophy or something else thrown in. I was like a polyglot. I loved, just any mix of anything was.
So was that a great class because it was interesting material, interesting teacher, or both?
It was sort of all the above, inspiring, awesome teacher, great material. I took a very similar class where you looked at aspects of history from all sorts of different perspectives, like the literature at the time, the first person account, never reading the transcripts of the Salem witch trials. It's just what a great time. Amazing.
All right. Well, that's what we have today, and we will see you next time on our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.